بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد وعلى آله وصحبه وسلم تسليما كثيرا. الحمد لله رب العالمين. We have reached the book on hires from Mukhtasar al-Quduri, from the section on financial transactions, al-mu'amalat. And we gave a little bit of an introduction to al-ijara last week. One of the books that students of knowledge unreasonably neglect, and this of course not necessarily at the level of someone who's beginning their studies and studying al-Quduri as their first complete text in fiqh, but something to keep in mind in your journey as a student of knowledge. One of the most brilliant books in Hanafi fiqh and one of the clearest books, and a book very useful in understanding the background of rulings and their wisdoms and their bases in very clear language, is Bada'i' al-Sana'i' of al-Kasani. He wrote a commentary in this work on his teacher's book Tuhfatul Fuqaha, and added a lot of points of benefit to it. But there's a few things that we'll just to give a framework to the text, because Kitab al-Ijara is very significant, right? So he has a really nice discussion on Kitab al-Ijara, on the basis of the permissibility of ijara, what's the integral of ijara, of hire, its meaning, and its conditions and integral, right? So a contract of hire is permissible according to the generality of the scholars, right? Primary legal reasoning would consider ijara to be problematic. Why? If we take the basis of transaction to be aqdul bay'a, right? What you are buying in a sales transaction is a tangible matter of recognized value, right? In a contract of hire, it's not an exchange. You're not taking ownership of a matter of value, but it is of a manfa'a, of a benefit. But that benefit is renewed time after time. So when I say, let's say for example, I go to work for entrepreneur sister. So she hires me for 1 month for $1,500 full time. It's unreasonably low, but she's a tough person. So I'm going to work 40 hours a week for I negotiate $1,600, right? $400 a week. So what happens? I'm getting paid for this, but it kicks in moment by moment. But it's permissible. Why? By Quran, by Sunnah, and by legal reason as well. Right? As for the Quran, right, number of verses, right, from the story of Sayyidina Musa alayhi salam with the father of the two women whom he prepared whom he drew the water for, right? From Surah Al-Qasas, verse 27, right? إني أريد أن أنكحك إحدى ابنتي هاتين على أن تأجرني ثمانية حجج. I wish to marry you to either one of these daughters of mine on condition that you work for me, and تأجرني for 8 years. And other texts as well, right? And the response, one of the daughters said, also from Surah Qasas, verse 26, Ya abati ista'jirhu, hire him. Inna khayra man ista'jarta al-qawiy al-amin. The best of those you can hire is someone strong and trustworthy. Okay. And this is, of course, shar'u man qablana, from the sacred law of those who were before us, but when it's related to us with approval, it's shara' for us. Of course, in the verse, there's also the two distinguishing qualities of someone you hire. Al-qawi, the strong, is someone who is most capable to fulfill the work at hand. That's strength. Right? قوة اقتدار على الإنجاز. The strength of ability to fulfill the work at hand. And al-amin, the trustworthy, who can fulfill what they're entrusted with of work responsibilities practically and morally. Right? And many general verses affirm it as well. From Surah Al-Jumu'ah, for example, فَإِذَا قُضِيَتِ الصَّلَاةُ فَانْتَشِرُوا فِي الْأَرْضِ وَابْتَغُوا مِنْ فَضْلِ اللَّهِ. Right? If the prayer is complete, then spread out on earth and seek from the bounty of Allah. And one of the means of seeking the bounty of Allah is to work for someone else. Right? Right? وَالْإِجَارَةُ ابْتِغَاءُ الْفَضْلِ. Right? Ijara is one of the ways of seeking the provision. Whether you work for someone or you hire somebody. Because why do you hire somebody? Not just because you want them to work for you, because you're trying to accomplish something of attainment of the bounty of Allah, material or otherwise, right? And that's from Surah Al-Jumu'ah and other verses. And from the sunnahs, from the sunnah of the Prophet ﷺ, right? There are many hadiths, right? That have come. Amongst them, the hadith related by Imam Muslim, that as part of a longer hadith, وَمَنِ اسْتَأْجَرَ أَجِيرًا فَلْيُعْلِمْهُ أَجْرَهُ. Whoever hires somebody, let them inform them of how much they're being hired for. Right? فَلْيُعْلِمْهُ أَجْرَهُ. Right? And that's related by Imam Muslim and others. And many hadiths. Right? The Prophet ﷺ said, أعطوا الأجير أجره قبل أن يجف عرقه. The hadith related by Ibn Majah and others, that pay the one you hire their wages before their sweat dries. Right? So of course the command is not to delay paying them unduly, right? But it understood from it that hiring is permissible, right? So that's textually. As for the scholarly consensus, ijma', then the ummah is in agreement. Actually, they relate one scholar who disagreed, right? Whose name is Abu Bakr al-Asam. But Allah knows best what exactly he meant by that. It may be that he just meant that the qiyas is that it wouldn't be permissible. But Al-Kasani points out that well before Abu Bakr al-Asam, rahimahullah ta'ala, there's clearly established consensus of the ummah that ijar in its various types, hire and rent and lease, all of those, fall under ijar, that it's permissible, right? Right? So, and that's why the primary line of legal reasoning was left for ijar. And Al-Kasani mentioned something, that's why I wanted to share this, to understand. He says, وَبِهِ تَبَيَّنَ أَنَّ الْقِيَاسَ مَتْرُوكٌ لأن الله تعالى إنما شرع العقود لحوائج العباد. Says, because Allah Most High only legislated contracts for the needs of His servants. وحاجتهم إلى الإجارة وحاجتهم إلى الإجارة ماسة, and their need for contracts of hire and rent and leasing is pressing, right? Because not everybody has a house in which that they can own. Not everyone has their own business. Not everyone has their means of transport. So being able to rent a house, to lease a car, or lease an animal to be able to ride. Not everyone can have their own business to be able to work for somebody else. Someone needs people to work for their business. So from that, we see that this clear need of people brings out the hikmatul mashru'iyya, the wisdom in the divine legislation of ijar. Right? And he has a very nice discussion there, which, just make a note to check. It's a few pages, but it highlights many useful meanings. Right? Right? And this idea of fulfillment of need, right? The integral of ijar is ijab and qabul, right? Is ijab and qabul, offer and acceptance. Whether in word or in any action indicating that, right? Indicating ijar. And then the meaning of ijara, right, of hire, is bay'ul manfa'a, is selling a benefit. It's a sale of a benefit. That's why the people of Medina frequently referred to hiring as with the term bay', sale, because it's the sale of a service, right? Right? And then there are details that we won't get into. So let's get back to Quduri. He says, الإجارة, قال الإمام القدوري رحمه الله, الإجارة. الإجارة لغة. So he says, الإجارة عقد على المنافع بعوض. So the ijara, hire, is a contract for benefits with exchange, right? بعوض, right? So ijara in the ijara can refer in the Arabic language to the ujra, which is the payment given for a service, or to the exchange of a service for payment. The technical meaning, عقد على المنافع بعوض. It's a contract over a benefit for exchange. Right? Now the contract kicks in moment by moment. Right? The service contract kicks in moment by moment. Even if, so, of course, if you leave aside the urf for a second, if you hire someone for a month and they quit after 8 days, what do you have to pay them for? Is what they worked. What they worked. Right? But as you can see in the Majalla, for example, and elsewhere, لكن لا يجوز فسخها إلا بعذر معتبر. It's not permitted to cancel. It's a binding contract, so you cannot annul it except with a reasonable excuse. Right? ولا تصح حتى تكون المنافع معلومة والأجرة معلومة. Right? It is not permitted to enact an ijara contract, a hire, rent, or lease contract, unless the benefit is known and the payment is known. Right? The benefit, المنفعة أي بما تزول به الجهالة الفاحشة. That is defined such that the major jahala, non-definition, is lifted. Right? So what are you hiring for, and what are the key qualities? And it's recommended to define it fully enough that minor non-definition is also lifted. And the price be known. Right? Right? Because and he mentions a broad principle in the commentary, لأن الجهالة في العقود في المعقود عليه وبدله تفضي إلى المنازعة. Because non-definition in that which is the subject of the contract, the معقود عليه, and in its payment, lead to dispute. And everything that leads to dispute corrupts or invalidates a contract, depending on the degree of non-definition. Right? And what's the subject of the ijara? Item 420 of the Majalla, المعقود عليه في الإجارة المنفعة. The subject of the contract in the ijara is the benefit being provided. And then he says, رحمه الله تعالى, وما جاز أن يكون ثمنا في البيع جاز أن يكون أجرة في الإجارة. Anything that is valid to be a price in a sales contract is valid to be the ujra, the rental payment in ijara. So the price can be material. That just, I rent this table from you for $50 a month, But I could rent the table for a book. Because could the book be the payment for something? Yes. So this is a broad principle. So anything of recognized material value. Could you exchange one service for another? Yes. But that can get messy. Right? Can you exchange one service for another? Yes. But it'd be probably better to break it into 2 contracts. Just so that you avoid complication. Right? What if one person is not able to do one thing? Then they can be offensive about canceling the other thing, etc. So it's better to keep this contract simple. Right? And practically in our time, it's better just to specify material value. So you want to hire that table for 6 months and you'll pay with a book. But what if then you give it back early? What are you going to do? Split the book in half and so on? So it's simpler to break it into 2 contracts. Rent it for $60 and buy the book for $60, right? So you separate it into 2 contracts. Okay. Now, depending on the benefit, let's look at a simple scenario. Sidi Zain decides to paint houses. Right? I call weekend painters. Right? So, travel for the weekend, we'll paint your house. Now, how could you charge for it? And this always causes problems. You could charge for the hours worked. Right? I'll work full day Saturday, full day Sunday to paint your house. Now, what are you being hired for? Right? To? Certain time. Now, you're being hired either, so paint my house this weekend. Now, if you say this weekend, reasonable assumption is, if you're doing it full time is 8 hours. So you should make that clear. But then, what is the contract? Is it to paint the house or to work 8 hours? The one doing the work, what would you try to claim? The hours. I did 16 hours. You hired me for 2 days. 2 days equals 16 hours of full-time work. I did 18 hours. It's not my fault your house is so big, that's your problem. And you made all these extra requests. What would the person hiring want? Paint my house. I don't care how many hours you did, that's on you. So what's that going to lead to? Dispute. Most contracts of hire, especially when they're not being done professionally, because professional contracts take these kinds of things into account. It leads to dispute. Now, as an aside, it's a serious bid'ah to speak ill of the Muslims. عموما أو خصوصا. Right? And there's bad social media habits. Don't even look at it because turithu dhulma. It causes darkness on the heart. People sharing memes of young students of knowledge that there were tasbeehs and shukr hat and this and that. Someone made a little meme with a seeker's thing of someone puts on shukr hat, takes a seeker's guidance course, buys a fancy tasbeeh from so on, and drinks expensive coffee, and they become a student of knowledge. Someone asks, what do you think about that? I don't think about it, because don't think of useless things to the extent possible. We all have our fudul, but things like that, when it's done, it's not good. Right? Allah subhanahu wa ta'ala, قُولُوا لِلنَّاسِ حُسْنًا, say good to people. The first person you talk to is yourself. Right? So speak good to yourself, which is your inward thoughts. Right? So, right? Um, right? And they say حسن الأعمال نتائج حسن الأحوال. Good actions are a result of good states. So if you're having negative talk to yourself, or let alone negative talk to others, sign of negative states, so don't. When you find those urges, have mujahada. Right? Curb the وَمَن يُوقَ شُحَّ نَفْسِهِ, whoever shields the negative qualities of their self, they're the ones who are successful. Okay? So don't. So these kinds of things lead to dispute. In a contract, it is recommended to make outcomes clear, particularly when when practically there'll be lack of knowledge, right? So let's say Sidi Zain starts a company. He's not going to paint. He's going to hire young people to paint. He calls it taqwa painters, right? So if you hire, you said you can hire in two ways. If you want us to paint your whole house, right? We'll give you an estimate, and we'll paint your whole house, and give you an estimate how many hours it takes. But if it takes longer, we'll take longer. You have one option, right? So we'll inspect the house, give you an estimate, full house painting. Or we can do it by hour, and we define what we do per hour, give an estimate of how much we're normally able to paint on an hourly basis. These are the breaks our employees take, etc., etc. You make the details clear, and you hire by hour. If we get the whole thing done, we do. If we don't, so you can choose which two contracts. And we recommend you take this one, because nusх in transactions is recommended. Right? Not cheating or deceiving the other person, or not causing them to be harmed in a clear way, is obligatory. There's an obligatory nusх. But there's a recommended nusх, which is to keep in mind the best interest. I paint half, entrepreneur sister has a new building. My paint company says we'll do 100 hours of painting, we paint half the building. I say, ma salama, we're done. What you going to do with the next half? So one needs to be aware of these things, and many, many other examples arise. With employees, I hired you to complete this project. Oh, you hired them on an hourly basis. So one needs to be aware of those matters, right? So that's why he mentions, because this is the immediate thing that arises in a contract of hire. Right? Let's say Sheikh Yusuf is an expert editor, because he spends so much time on English style and usage and grammar and all these things. So we hired him. I'm hiring you to edit this book. But when he sees the book, it's a disaster. So he thought it would take 50 hours of work, and so he gave his rate. You said, no, I want you to edit the book. Let's tawakkal now. No. If you start that contract without being clear on what exactly is due on one party and what's exactly due from the other party, you've entered into a aqd fasid. You've entered into a corrupt contract, and that's like being in a state of riba. It's a bad state. Sinful. Even if no dispute arises. But disputes arise all the time. So, he tells us, rahimahullah ta'ala, وَالْمَنَافِعُ تَارَةً تَصِيرُ مَعْلُومَةً بِالْمُدَّةِ كاستئجار الدور للسكنة والأراضين للزراعة. Benefits are sometimes defined by time period, right? Such as in hiring residences, right? For a known period, for a month, for example, for residences for dwelling in, or land for agriculture. I want to hire this land for 2 years. Right? It's valid. فيصح العقد على مدة معلومة أي مدة كانت. In such a case, the contract is valid for a known time period, regardless of the length of the time period. Whether lengthy, 99 years, long lease, or short, a month, a week, a day, hours, right? In some airports, they have these little closet kind of rooms that you can stay in for a couple hours, for like nap rooms. I stayed in one I paid for a day. It was kind of cool little cabin kind of thing. But there's no place to pray. Like I had to move my suitcase and my carry-on into the washroom area, which wasn't a washroom. It was just like connected to it. Like it was all like one cabin, like to be able to pray in. But anyways, so it could be even for a brief period of time, right? As long as it's defined. Now, in some places, there are certain properties that the ulama treated with particular caution because of the texts that have come regarding them, which is the mal al-yatim, right? And likewise the mal al-awqaf, right? So if someone is taking care of an orphan's property, for example, likewise waqf property, and it's shocking actually how much of Turkey was waqf. There's a good article by Sheikh Khalil Abdul Rashid, I think the Yaqeen Institute published it, on reviving endowments, and he studied extensively in Turkey, hafidhahullah. But it's shocking how much of Turkey is awqaf and how many awqaf are there. But anyways, so you're responsible for a waqf. The danger in renting it out for really long-term rental is then people can start claiming that it belongs to them. And this was actually a serious problem that happened with a lot of waqf land. Because wealthy people, they'd be encouraged. In your own lifetime, you're wealthy and you want to do something good, turn some of your property, make it waqf lillahi ta'ala. And the rent earnings from it can go to support Islamic projects. So a lot of, and there's a whole system of awqaf, and that's something that needs attention and renewal in our times. But those are contextual. You'll find rulings related to that. Some mention about al-Maydani, that they said to limit that, but that's not an absolute ruling. That's in order to avoid the harm. Like if you have a long-term waqf, so they said waqf property should not be rented out. How much mentioned in Lubab? I think 3 years. But that is, مبني على العرف لحاجة or لدفع ضرر. Is based on urf in order to avoid harm, lest people claim, right, that, well, we've lived there generationally, so it's ours. Okay. وَتَارَةً تَصِيرُ مَعْلُومَةً بِالْعَمَلِ. And sometimes the benefit is defined by defining the work. والتسمية, by naming it. كمن استأجر رجلا على صبغ ثوب أو خياطته. Such as if you hire a person to dye a garment or to stitch it. Right? and you made the relevant details clear. وَبَيَّنَ الثَّوْبَ وَلَوْنَ الصِّبْغ وَجِنْسَ الْخِيَاطَة. And you made clear the garment in question, the color of the dye, and the type of stitching. Right? بما يرفع الجهالة. Right? Right? In a manner that lifts non-definition. And you can see in Hashiyat ibn Abdin, it's volume 5, page 8, I believe. أو استأجر دابة ليحمل عليها مقدارا معلومة. Or if one hires an animal to carry upon it a specified amount of things. Or to ride it for a particular distance. Right? So, like if you started a rental company, you could define either days of rental, or you could rent by mileage, right? Or some combination thereof, right? By making one the asl and the other a wasf. But in most of these situations, looking at what are the customary contracts is insightful. Because let's say, Enterprise Sister Cars, right? ESC. You rent out a car for 2 days, but the person drove it 48 hours. They just drove 48 hours at high speed. Would you be happy with that kind of usage? No. Right? So those things should be in the contract, limited by fair usage. Right? Those are, and then the person would be bound by those conditions. Right? And of course, here we have to keep a principle in mind that al-ma'ruf urfan kal-mashhud shartan. That which is customarily known is as if contractually stipulated. So if someone rents a car and they rode it 24 hours, would that be considered reasonable usage? Would it? No. Let's say, I quite like cast iron pans. I own a couple myself, but technically they belong to me. They're not like just household items, right? Now let's say I start renting out Rabbani cast iron, right? So I rent out this cast iron skillet to Sidi Hamza. Sidi Hamza decided to make 3 months worth of waffles that he's going to, freeze and start his waffle company. So but he wants to save on money. So he rents my skillet and he uses it 48 hours continually. Right? That's a lot of wear and tear all at once. I may not be pleased with it, right? So you could just define explicitly fair usage, right? Right? But then how do you penalize things like that? That's where amana comes in. Because there are only certain types of penalties that are allowed and not others, right? Okay. So they can be defined firstly by time, secondly by action. وَتَارَةً تَصِيرُ مَعْلُومَةً بِالتَّعْيِينِ وَالْإِشَارَةِ. Sometimes the benefits are defined by pointing to them or indicating them, right? كمن استأجر رجلا على أن ينقل له هذا الطعام إلى موضع معلوم. Such as if you hire somebody to transport this food to a known place. Right? So this is known dilalatan. Right? It's known implicitly. And then, now let's say I rented my cast iron skillet to Sidi Hamza. Then I said, I'm not going to give it to you until you pay. And we hadn't stipulated anything. Because of the nature of ijar, of hiring, unless we stipulated advanced payment, it's mentioned in the Tanweer, وَالْأَجْرُ لَا يَلْزَمُ بِالْعَقْدِ. The payment in ijar is not required in the upon contract. فَلَا يَجِبُ تَسْلِيمُهُ. You don't have to pay in advance. Right? Unless it was willfully paid in advance or contractually stipulated to be paid in advance. Otherwise, it is required upon usage. Right? And you can see that's on page 6 of volume 5 of Hashid ibn Abdin. But practically, this should be stipulated, because again, it leads to dispute. When is the payment due? And then he says, rahimahullah ta'ala, and here, just, I don't want to go into too many of these. In Murshid al-Hayran, you do well to look at items, maddat, 562 to 565 from Murshid al-Hayran of Quduri Basha. (562 to 565). ويجوز استئجار الدور والحوانيت للسكنة وإن لم يبين ما يعمل فيها. It is permitted to rent out residences, dur, right? والحوانيت, and stores, right? الحانوت, حوانيت is plural of حانوت, وهي الدكان, right? Which is a store. For residentially or for anything else, even if you don't mention what you're going to do in it, right? Because residences are customarily known. Why do you hire a residential property? To live in. What do you hire a shop in? To open some kind of store. And of course, مطلق التصرف يقتضي السلامة. In general, any human action, there's an assumption of soundness. Right? So, but who is responsible for sound usage? The government. In the sense that someone rents a house and they use it for a prostitution ring. Are you culpable as the person renting out the house? No. That goes back to enforcing the law. And now if there is law governing renting houses, etc., both the one renting out and the renter have to comply by the law. And it's, and that's the preservation of public interest, is the responsibility of who? Of the government. Frankly, at the individual level, I rented out the house. What you're doing with it, I'm not responsible to find out. Now, if people frequently use that for pernicious uses, that goes back to the government. And what my duty is to obey the law. It's recommended for me to avoid someone using it in socially harmful ways. But I am not obligated to verify preservation of public interest, because that's not my specialty, right? So, وَلَهُ أَنْ يَعْمَلَ كُلَّ شَيْءٍ, right? And one can do in it anything, right? But the condition is مِمَّا لَا يَضُرُّ بِالْبِنَاءِ, of that which is not harmful to the property. إِلَّا الْحَدَّادِ وَالْقَصَّارِ وَالطَّحَّانِ, except for working, using the place as an ironsmith. What is the qassar? Bleaching, right? وَالطَّحَّانِ, milling. Why? Because all of these harm the building. With milling, because there's heat and, in the milling, a lot of dust and stuff comes out, and it disturbs that property and surrounding properties, right? Because there's manifest harm. So that would have to be stipulated, right? And this goes back to, there's a principle, لَيْسَ لِلْإِنسَانِ إِضْرَارُ مِلْكِ الْغَيْرِ. One cannot harm another's property. لَا ضَرَرَ وَلَا ضِرَارَ. Right? And here there's two important things, which is مع رعاية العرف, with taking into account urf, established practice, and number two, the law. So for example, and people make serious mistakes with it, and in shar'an, and it's not, some people take the law as if it's sort of, someone is running a business, a retail business out of their garage. Is that permissible? No. Well, nothing. It's not permissible. Why? Because that's the law. Now you're not there to determine public interest. Who has the responsibility of determining what's in the public interest and what isn't? The government. Are you the custodian of public interest? No. So you say that doesn't make sense. In some cases, there's a tadyiq ala al-amma. Certain rules could be excessive, but you can't give yourself a fatwa, because you're not there to determine public interest, and number two, you're not a mufti. So you're making at least two errors. Okay? You gave yourself a fatwa on a matter that you don't know about. So you're not a qualified mufti, you don't know what the public interest is. Do you know why that regulation's in place? No. والأصل أن الناس إنما تعارفوا أمورا لما يرون فيها من مصلحة مظنونة. Because the basis is that people only establish certain norms because of what they see in it of perceived benefit. So you don't know why they did it. So, unless something is clearly limiting, right? So, one is bound by that. Are you allowed to sublet? In many places, you're not allowed to sublet. So, the worst thing is if you agree to it in the contract, right? It's a divine command. Forget the law. يَا أَيُّهَا الَّذِينَ آمَنُوا أَوْفُوا بِالْعُقُودِ. O you who believe, fulfill your contracts. Right? And otherwise, mal haram. Right? The earning is haram. Like, people take it as is voluntary. You agree to something contractually, and then don't do it, say that was unreasonable. If you agreed to it, that's the worst case. But then the second level is, what's the law? Right? And the basis is you must obey the law. The third is the urf. Because al-ma'ruf urfan kal-mashruti shartan. What is customarily known is as if contractually stipulated. So, let's say you, entrepreneur sister, decided to open if you start a halal restaurant, what do you start? Yeah, something sweet. Call it something sweet. Now, you want to catch the breakfast crowd. So what do? But the mall closes at night. So, but you have the keys. So what do? You get your employees to come in from the loading area. They go to sleep early. You convince them to do this. And they start baking at midnight on premises. And, so 7 in the morning, you've got all this fresh stuff there. Now, would the mall, even if it's not in your contract, customarily, would people be okay with people being in the mall after it's closed? No. Okay? It's probably there in your contract that you can't do that. You can't stay overnight. Okay? So you have to consider what's in the terms of the contract. Number 2, the law of the land. And the law of the land is at all levels. National government, regional government, local government. And sometimes there's 3-4 layers of government, but that's it. They're all there to protect the public interest. If you really don't like it, migrate, right? Or protest. But you protest while upholding the law, right? Unless there's civil disobedience, but it has to be done with civility and with principle. Right? And number 3, custom. Because what if someone didn't stipulate it, and the custom is, if you ask 10 people, would they say that's reasonable? 10 upright, trustworthy people, not people without principle. Right? And there's all kinds of, you can get away with it. This is a means for bankruptcy, spiritually and morally. And of course, but if you stipulate, then the stipulation is binding. If you stipulate, then the stipulation is binding. So if you rent an office space, what have you rented it for? To use as an office. Can you live there? No. Why? Because that's not what it was hired for, number 1. Number 2, is that a customarily accepted usage of that space? No. People make all kinds of mistakes. You rented a space. Now you're using it for the sake of Allah, or you're using it as a temple for whatever. That's your issue. But contractually, if your term is over, so I'm renting from Sheikh Yusuf. Sorry to put you on the spot. Okay? Now, he has many high aims in mind. Right? He wants to start the Yusuf Institute for whatever. He realizes the market value of the property, rental value, is twice what it is. So he ups the rent. As long as he's not breaking the law. But the reason this is important, understanding these principles, because people fall into errors. It's your property. I'm renting it. Time comes for renewal. Is it my haqq to renew? No. You own the property. I'm renting from you. Now, you want to raise the rental price, that's your haqq. Now, if there's laws limiting rental raising, then you're bound by those laws. So let's say you raise the price. If I refuse, and then I criticize you for raising the price, what is that considered? It's slander. And worse. Like, it's slander and many degrees of dhulm. It's slander, it's besmirching another's honor. Like, that's كل التعدي على العرض. Right? So I didn't mention them. So, yeah. What dilalatan is the owner of this property. Right? The owner of such and such property. Right? Someone else checks. If someone else goes, they don't rent out that property. Why? Because I badmouthed you online. Right? So that's ta'addi. People do that all the time with work situations. Someone didn't renew someone else's contract. Do you have to renew someone's contract when it's done? No. And then to go and say things about them, right, whether it's to do with a property or an employee, they didn't want to continue, or an employer, and to say things that falls under backbiting or slander, tale-bearing, also besmirching the honor. كل المسلم على المسلم حرام دمه وماله وعرضه. Right? So these matters, there's a lot of ethics related to the transaction that one needs to be aware of. And لا لزوم, and there's a broad principle, لا لزوم إلا بالتزام. There's nothing required upon you unless you take it upon yourself. It's your property. مقتضى الملكية حرية التصرف. The basis of ownership is that you have the right of transaction. Right? Sidi Hamza really liked the mic. So we discussed that maybe I'll upgrade my mic and sell you this one. Did I sell it to you? So you came 2 weeks later because you decided to start Khancast, right? A podcast about all thoughts related to a talib ilm. If you do that, I'll ban you from class. So keep that in mind, inshallah. Right? You want to start Khancast. I didn't sell it to you. Do I have to? No. Now, for you to say, even have negative talk to yourself about it, the more cautious opinion is that negative self-talk is sinful. إِنَّ بَعْضَ الظَّنِّ إِثْمٍ. Let alone if you speak to others about it. Okay? Or you said, I'll come tomorrow and buy it from you, inshallah. You didn't come for me to say anything bad about you. And look, he promised he'd buy it. مَا لَكُمْ كَيْفَ تَحْكُمُونَ. Right? What's up with you and how do you judge? Do you have to fulfill a commitment like that? No. Because you were genuine, you wanted to buy it, but then you went and checked your bank account. And you're like, oops, I don't have the money. I'd made many other commitments. Lesson learned, it was contrary to what's recommended, but it's not binding upon you. So these happen a lot with higher situations, right? Keep those in mind, inshallah. Right? ويجوز استئجار الأراضي للزراعة. It's permitted to rent out land for agricultural purposes. Right? ولا يصح العقد حتى يسمي ما يزرع فيها, and it is not valid to make that contract unless you specify what you will grow on it, right? Because different things have different impact on the earth, right? And some harm the earth more. You plant trees long term, etc., right? They grow roots and they could affect, so this can lead to dispute. أو يقول على أن تزرع فيها ما شاء, right? And يزرع فيها ما شاء, or you make it general, such that you can grow on it whatever you will. Or if there is urf indicating what would be allowed, right? So you rent someone's fruit orchard, it already has trees. Or let's say I'm renting your orchard, and it's known that in that land they grow certain things. Then what will you be growing? Those certain things, right? ويجوز أن يستأجر الساحة ليبني عليها أو يغرس فيها نخلا أو شجرا, right? It's permitted to rent a saha, which is an open space, right? An open space which is defined legally as الأرض الخالية من البناء والغرس, a land that is free of building and plant, like an open space, in order to build upon it, because remember, rent can be long term, right? And he'll tell us what happens to the building then. He'll tell us in a moment. Or to grow something upon it. The recommended in these kinds of situations, because let's say, real case, entrepreneur sister leases out this land for 30 years. I build upon it. I own the building, she owns the land. But when the lease is over, what happens? She has the right to the land, I have the right to the building. But do I have a right to keep my land on your building? No, because you're building. So entrepreneur sister knows all these things about building. It's recommended to lay out the consequences of what could happen, the outcomes in the contract. So that the other party is over, because 30 years are over, I start huffing and puffing, well, I build, So it's best to lay those terms out. If I want to build something, build it in a way that I could move it. فإذا انقضت مدة الإجارة لزمه أن يقلع البناء والغراس. But then if the time period of rent is over, it is required of the one renting to remove the building or the crops. So you planted trees there. وَيُسَلِّمَهَا فَارِغَةً, and to deliver it back free of any of your property. إلا أن يختار صاحب الأرض أن يغرم له, unless the owner of the land agrees to compensate them for it, and that will be a separate contract. So, okay, I'll keep I'm fine with, I'll pay you $200,000 for the house on it. That's a separate contract, right? قيمة ذلك, for the value of that. مقلوع, يعني مقلوعا فيملكه. For the price of that, separate of the land, but that's if based on agreement, right? And they can set whatever price. There is one exception which is mentioned in the commentary, unless the land would be significantly harmed by removing what was built upon it, right? So or the trees that were planted. So someone planted trees that take such deep roots that if we pluck them out, experts are saying that this could cause a collapse of, it could cause sinkholes, for example. And there's some places that have sinkhole problems and so on, right? So then you'd be required to compensate, say, okay, we have to then keep the property on those trees on that land, or the building on that land, and they can either agree that, look, more diyanatan, you have to agree for me to keep the tree, and morally I am obligated to pay you the market value of that, and it'd be recommended to give a little more. But can I force that on you? No. You say, no, I don't believe it. Then we go through the stages: mutual agreement, mediation, arbitration, adjudication, or court. Okay, there's 5 stages of dispute resolution. There's nothing called public opinion, right? Nothing called public opinion, right? It's not a hakim in the shara. Right? So I'm going to take you to social media. That's a type of dhulm. Right? We differ. We either resolve it between us, we seek a mediator, an arbitrator, an adjudicator, or we take it to court. And then there's Yawm al-Qiyamah and the Ahkam al-Hakimin. Right? But just taking it to court, except in very specific cases of tadhalum, but that has very specific scope that the fuqaha were very, very cautious about, right? Because ما يفسده أكثر مما يصلحه. Okay. أو يرضى بتركه على حاله فيكون البناء لهذا والأرض لهذا. Or they are both satisfied to leave the thing in its state. So there's a plot of land, and the plot of land on one side and a building on top of it. So what happens? Plot of land belongs to entrepreneur, building belongs to Sidi Hamza. They say, look, I want to use the plot of land. I don't want a big hole in the middle. I'm fine with you keeping your building there. And they agree. Right? That's it. So your rent is over. You could agree to just renew the contract, but you don't want to renew it. Say, like, I don't want to renew. I'm kind of fine with you just keeping the building there. It doesn't hurt me. I get more clients because she's got all this, you got residential building, she's got all these commercial places around it. You say, you know what? Keep it there. That's fine too. But of course, it mentioned the Majalla and stuff. Imagine if you got a large property in the countryside. He built a residential building in the middle. So you agreed, you have to provide access to the building in general. ما لا يتم الحق إلا به فيدخل في العقد ضمنا. Okay? Anything that a right cannot be fulfilled without enters into a contract. Can you rent out a house without giving the keys? Can you? If you lost them, you have to replace the keys, right? Otherwise, the rental period doesn't begin until you give them usable keys. Because you cannot use a house without the keys. Say, enter from the balcony. No. That's not reasonable usage. Unless it's in an area where people normally agree to enter from the window. So if you build a building on someone's property, they can't say, but you can't enter my property. The property is mine. And it'd be invasion of privacy for you to enter. No, because if you rent it out, land in the middle to build a building, you have to provide reasonable access. You build a road, you can say, please stick to the road. Don't go anywhere else. That's your right. But you have to provide access. It's all common sense, right? Okay, ويجوز استئجار الدواب للركوب والحمل. It is permitted to hire animals to ride and to bear weight. They have rights. Animals have rights in travel, and they mention حقوق الحيوان, and they have mentioned extensive rights. The obligation, and basically in all rights we can think of them at three levels, right? العدل, المعروف, والإحسان. Justice, good, and excellence. So العدل, with respect to the rights of an animal, is أن لا يظلم, is that they not be wronged. The ma'ruf is that you fulfill their basic right and you do a little extra good. الإحسان is رعاية مصلحة الحيوان بقدر الإمكان, is to take good care of the best interest of the animal. And any animal that you use, that is the Islamic value in it. So when traveling, Imam Nawawi mentions of the 70-something adab of traveling, mentions 5 or 6 adab related to the animal. That and yura'i maslahat al-hayawan, that you carefully take into account the best interest of the animal, about how long you ride them, how much you ride, in terms of length, in terms of length of riding, how much you put on them, how often the animal rests, what you feed them, what you give them to drink, right? Etc. Because of the extensive amount of texts that have come with respect to taking care of the rights of animals, right? فإن أطلق الركوب جاز أن يركبها من شاء. If he says, with respect to a mount, and this will apply to a car as well, that you say to ride it, you can ride it yourself or let another ride it. This conditioned by 2 things, right? Custom would enter into it, of course, law, right? Right? وكذلك إن استأجر ثوبا لللبس وأطلقه. Right? Likewise, if you rented some clothing, such as people rent tuxedos or other dresses, you can wear it yourself or for another, but in that which is normally worn by one person, the permission is assumed to be for one person. So you rented a tuxedo for 2 nights, you can't wear it one night and let someone else wear it another. Right? For example. فإن قال على أن يركبها فلان. But if you specify on condition that so and so ride it, أو يلبس الثوب فلان, or that so and so wear the garment, فأركبها غيره أو ألبسها غيره كان ضامنا إن عطبت الدابة أو الثوب. But then if you specified who would be using it, right? Who would be riding or using the item, and it was specified because that specification is of consideration, because you may have approved. We went to Enterprise car rentals. They agreed to let me drive the car because I'm such a good driver, such a long driving history, etc. You may have approved me, you may not have approved someone less responsible. For that, I don't even have a driver's license, but if in another world, if I was, right? So in that case, if I had someone else use it, then, because in general, that which is rented, the yad, the one renting, it's an amana in their hands. When do you have to compensate for an amana? In two cases, broadly, which is التعدي أو التقصير, by transgression, by going beyond what is accepted, or by falling short of safekeeping of the item. التعدي أو التقصير. So here, if we specified who would be riding the mount, or in our times like the car, for example, you rented it, you let someone else drive it, or with the item of clothing, you had someone else wear it instead, but it was specified who it was for, then firstly, this is considered ghasb. This is considered ghasb, misappropriation. So the whole time, you're in a state of hurma, of impermissibility. You're morally culpable for the whole period. You have to rectify or cancel. Number two, if anything happens to it, it's not a case of, because your hand on over it now was not yadu amana, but it's yadu daman. You have to compensate for it fully. So anything happens to it, you have to compensate for it fully. So someone else was riding and another car hit it. You are culpable. Say, well, that person is responsible for the damage. No, you are responsible for the damage, because even if you didn't do anything wrong, any harm that happens to the property, when it's being misused, the yad there is yadu daman. It's very, very serious. فَكَانَ ضَامِنًا, one must compensate if the animal gets hurt or the thobe gets damaged. وَكَذَلِكَ كُلُّ مَا يَخْتَلِفُ بِاخْتِلَافِ الْمُسْتَعْمِلِ. And likewise, in any case where different users would use an object differently in terms of permission or in terms of potential harm on the item used. So then he applies this next to فَإِنْ شَرَطَ سُكْنَ وَاحِدٍ. Now this goes back to custom. Right? Now this is very important, right? The underlying principle is that when it comes to houses, can you fundamentally damage a house through wear and tear? Like a house is different from a donkey. In the old day, a donkey, small little person rides it, little wear and tear. Uncle who loves biryani sits on it, right? And it's a lot more wear and tear. Different drivers, right? An experienced driver in their 40s, the risk on the car is much less than a 20-year-old driver renting the car, right? So, but you rent an apartment. Unless you actively harm it in normal usage, would there be a difference? Not significantly. So that's why he says, this is a general principle, فَإِذَا شَرَطَ سُكْنَ وَاحِدٍ فَلَهُ أَن يُسْكِنَ غَيْرَهُ. If you specified for a single person, a particular person, to be the one living in the house, it's permitted for the one renting to let someone else stay instead. Because what's being rented out is the house. Right? This is unless the custom is to the contrary. Because, so here, إِلَّا لِعُرْف. unless there's an established custom, right? So, because custom and law are both considered, right? Some places they'll make that a condition, and the conditions considered. Is this a custom condition that's normally made? So that also has to do with subletting. Could you sublet? The assumption by default, no. People don't agree to sublets unless it's either allowed in the contract or it's customarily allowed. But it's contrary to caution, because some landlords may object, right? وإن سمى نوعا وقدرا يحمله على الدابة مثل أن يقول 5 أقفزة حنطة فله أن يحمل ما هو مثل الحنطة في الضرر. If one specifies a certain type or extent that would be borne by the mount, such as saying, 5 measures of wheat, then one can carry the equivalent of that wheat instead. So say, I'm renting this to transport 500 kilos of coffee. But the order changed. It's 473 kilos of tea. So it's a similar type. Right? وليس له أن يحمل ما هو أضر من الحنطة كالملح والحديد. But you cannot carry something that is more harmful than the wheat, such as salt or iron. Because wheat, the nature of wheat is that the weight gets distributed. And the fuqaha explained that with salt or iron, the weight gets concentrated in particular areas. So it imposes more harm on the animal, or more wear and tear on the mode of transport. This goes back to custom. وإن استأجرها ليحمل عليها قطنا سماه فليس له أن يحمل مثل وزنه حديدا. Likewise, if you hired it to carry a certain extent of cotton, you cannot carry the same weight of iron, because there are different characteristics. وإن استأجرها ليركبها فأردف معه رجلا فعطبت ضمن نصف قيمتها ولا يعتبر بالثقل. If you hired the animal to ride it yourself, and you had someone else ride with you on the animal, and the animal then is injured or dies, you have to compensate for half of its value, because you had permission to ride, the other person didn't. And in this case, weight is not considered, because it's by the usage there is considered by number of individuals riding. In the case of an animal, it would be different in the case of a car, because a car is not affected in the same way. So you cannot make qiyas on a car on this example, right? Because 2 people riding a car is not the same as 2 people riding an animal, for obvious reasons, right? But if you had 8 people ride a used car that has capacity for 4 people, right? Then you need a fatwa, right? وإن استأجرها ليحمل عليها مقدارا من الحنطة فحمل أكثر منه فعطبت ضمن ما زاد الثقل. If you hired the mode of transport to carry a particular amount of wheat, for example, or whatever, and one carried more than that amount, then you have to compensate, and then the animal or the car was damaged as a result. You have to compensate for that which was beyond the contractually stipulated amount. And if an amount wasn't stipulated, then if you went beyond what is customarily considered acceptable, then you would also have to compensate for it. And he says, وَإِذَا كَبَجَ الدَّابَّةِ بِلِجَامِهَا أَوْ ضَرَبَهَا فَعَطِبَتْ ضَمِنَ عند أبي حنيفة. Right? If one Kabaja is if you restrain the animal with its stirrup or hit it within the bounds of normal hitting of the animal, right? And the animal dies as a result, right? So you try to restrain the horse and it choked and died, it swallowed its tongue or whatever happened, right? It died. But you just did it normally. According to Imam Abu Hanifa, and interesting, one of the reasons they mentioned, because the Prophet ﷺ did not do this. Like he did not hit an animal, rather he nudged his animals. Right? And Imam Abu Hanifa considered hitting the animal not to be a need, because you can ride the animal without it. And it's not some hippie thing that we're making up, it's there in the texts, right? They say it's يتحقق السوق بدونهما, because it's possible to ride an animal without using the stirrup or hitting the animal. That's considered an unnecessary act. So then the animal dies as a result of it, you have to compensate the whole value of the animal. And there's difference of, so in many of the texts, I mean, Jawhar al-Nayyara mentioned the fatwas on the position of Imam Abu Hanifa, and this is what's mentioned in Al-Maydani quotes Allama Qasim in Al-Tasheeh, that's what's mentioned by Al-Mahbubi and Al-Nasafi. However, others took the position of the Sahibain on the basis of that compensation is only due if one used the animal beyond what is reasonable. So that's what we're covering today. Then he mentioned that there's two types of hires, right? There's وَالْأُجَرَاءُ عَلَى ضَرْبَيْنِ. There's two types of hires, أَجِيرٌ مُشْتَرَكٌ وَأَجِيرٌ خَاص. There's a shared hire and a personal hire. A shared hire would be, you have a designer, they're doing designs for you, they're doing designs for others. So they've not freed themselves up for you. The fiqh related to a contractor like that is different from someone you hire yourself. Because if you hired them yourself, then there's a sense of other rules apply. Can they do other work? Right? You hired a tailor to sew something for you. They're stitching for you, they're stitching for others. So that differs from you hired a tailor full time. And that's one of the things, the rules related to hire differ on what type of hire are they, and what they can do and what they can't do. And again, a lot of people, and the Prophet ﷺ promised, and it applies not only to fitan, it applies to all human actions. فَإِنَّهُ مَنْ يَعِشْ مِنْكُمْ فَسَيَرَى اخْتِلَافًا كَثِيرًا. So someone gets hired to do work for you, but they're doing whole kinds of other work, and that mal is haram. Why? Because if you are a full-time employee, the basis is it is not contractually permissible for you to do the same work elsewhere. إِلَّا بِالْبَيَانِ, except by making that clear. وَالْجَهْلُ لَيْسَ عُذْرًا. And ignorance is not an excuse. Right? Now, you can't do that. I should probably put a bookmark in here. You can't do that, and we have to treat work, any kind of work with the same standards. Okay? And this is an area where people are very negligent, right? They, and this is one of the big problems the non-profit sector has in general. Even in the broader society, people consider that, corporate work is real work, non-profit work is, I'm doing something good. And there's something called, there's moral justification. Yeah, that you have to be very aware of immoral work in doing moral work. Because the human self, just called moral justification. And there's other titles. Because you're doing something good, you feel like, what's so bad about it? I'm already doing something good, therefore I can get away. And the ulama used to warn that beware of bad deeds that come after good deeds. Why? Because someone goes praise Isha. So you feel, okay, I did this good deed. After that, if you're not careful about your nafs, what happens? You feel less bad about going and committing some quote-unquote petty sin. Why? Because you just did some good. إِنَّ الْحَسَنَاتِ يُذْهِبْنَ السَّيِّئَاتِ. Good deeds wipe away bad deeds. I did such a big good deed, get away with a few bad deeds. Be very careful about that. نَفْسُكَ حَيَّةٌ مَا دُمْتَ حَيَّةٌ. Your nafs is like a snake. حَيَّةٌ مَا دُمْتَ حَيَّةٌ. As long as you're alive. But this happens in transactions as well. In the non-profit sector, people complain about that this is an established harm. It happens all the time in Muslim organizations. Someone's trying to start their own business, so they're working full-time for a Muslim organization. But what are they doing actually? They're putting most of their effort in establishing their own business. You have to make bayan about things like that in advance. So recently we hired somebody as a person of principle. He made very clear that this is what I'm doing right now. Mentioned this. Are you okay with this? Say yes, let's agree to that in writing. Okay. Then within those bounds you are in hil. Right? And same, because the one who's hired in any position, they're mu'taman, they're trusted. We had a case a while ago. Someone was hired and they tried to hire somebody. Turns out that they're already working with this person in another project. That's conflict of interest. That's khilaf al-amana. Islamically, you're obligated, you're committed to sin by not making that clear. Right? Someone recommends, hire this person, but you don't say it's my wife. That's a problem. Right? Because you have to allow someone else to make the decision on that case. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين. Yes.
In the text, that's the person who built something on the land or has crops has to either give back the land free of it, or they can agree to have it there and they would own the building, or they could sell it for qima. Is what's meant here by qima the market price? And if so, why does it have to be the market price of the building?
No, it's the price that they agree to. Okay. Except in the case where it would harm the property. Right? They planted trees that have very deep roots, and it would somehow, and that of course, ما رجع ما كان مرجعه إلى الرأي فيعتبر رأي أهل الخبرة. That which returns to expert judgment, what counts is people of expertise. The fuqaha differed, is one expert person enough or two? Right? They have to be expert and they have to be upright. For obvious reasons, right? Because they're giving witness.
I didn't understand the reasoning for if someone placed the second person behind them on an animal died or was injured, why do they only have to pay half? I don't understand the wisdom.
Because 50% was permitted usage, 50% was not permitted usage.
So what if the animal could not bear two people and that was not done before?
But it could bear one person. So the transgression was 50%.
But you killed an animal, wouldn't that if that was someone's means of livelihood, wouldn't that cause a lot of problems in their life?
Not necessarily. Well, that's subjective. That's a good question. So let's look up the answer together for that. Why is only 50% due, not 100%? You guys should be able to find the answer.
In Shaykh Faraz's commentary, he mentions that 50% would be due if the animal could carry two people. And the animal's
That's why. So no, but let's find the answer. That's why you should be able to find the answer. That is not an independent. That's not a nas. Find the actual text. The answer is there. That's basically the answer, right? One case where the animal a donkey can carry two people, but it happened to die when you carried to people, that's when 50% is due. But if the animal is such that you hired, what's a animal is barely capable? Yeah, you hired a pony and you had two biryani lovers rode the pony. One would be barely enough, right? Then full compensation would be due. But the detail, but you can find the nas related to that. Okay, I need to stop here. So, Allah, I say